Professor Zuleta might be the first one to answer, then Professor Bermann. It is the following. In our opinion, seeking interim relief from a judicial authority, especially before the formation of the tribunal, is incompatible with emergency arbitration. We are aware that some arbitral institutions, such as ACDR and ICC, expressly state in their arbitration rules that there is no incompatibility in this regard, but we would like to hear your thoughts on this issue, especially considering that some institutions and countries might lack guidance and practical experience on this topic.
Well,
I think you were first.
okay. Okay, good afternoon. Can you hear me from here? Okay, good afternoon, everyone. It's a great honor and a pleasure to be here, particularly with Professor Bermann, whom I admire a lot. And in connection with this particular question as to whether the so-called emergency arbitrator is incompatible with other court actions, the answer to that is, as a general rule, no. The rules, and I'm going to refer specifically only to the ICC rules, because given the fact that I had the opportunity to participate in the drafting of the rules. In the case of the ICC, it is clear from the rules, not only the article in the rules, but the annex regarding emergency arbitration, that the acts or the decisions of the emergency arbitrator are not incompatible with the decisions that can be taken from the courts. Now, that does not mean that there's no problems in connection with emergency arbitrators issuing decisions and then the courts issuing parallel decisions or contradictory decisions. And the problems, of course, arise in several aspects. Number one, because as I said, the emergency arbitrator could clearly issue an emergency decision before the arbitral tribunal is formed, is constituted. But so can the court. And then there could be a clash between the two decisions. Two, because once the arbitrator tribunal is constituted, then it is the arbitral tribunal the one who can issue interim decisions or decisions interim decisions. And then at that time, it is the arbitral tribunal the one who can issue the decisions. The emergency arbitrator is no longer in place, but then there can be a contradiction between the decision of the court and the decision of the emergency arbitrator. And last but not least, the clash results, or the problem also results from the way in which the parties select the type of measure they want. Because number one, the emergency arbitrator has a limited scope of activity. Number one, generally would be difficult, and we will go into that later on, for the emergency arbitrator to issue ex parte decisions, which a court can. Number two, because clearly the decision of the emergency arbitrator can be revoked by the tribunal once constituted. It is not clear that the decision of a court can be revoked. And it depends on the venue, it depends on the seat of the arbitration, and depends on the applicable law. So in short, they are not incompatible. And in practice and in fact, they can and in fact go at the same time. And we've seen a number of cases in which you have decisions on the part of the emergency arbitrator on the one hand, the courts on the other, with the caveat and the problem that the decision of the emergency arbitrator can clearly be revoked by the tribunal. But there are doubts as to whether the decision of the court can be revoked by the tribunal. That's one thing. And the second thing is whether, we will see that, the decision of the court can be contradicted by a decision of an emergency arbitrator. So there is clearly a clash there. The purpose of the emergency arbitrator was to some extent, to avoid the possibility or to expedite the possibility of the party asking for expedite measures, particularly in cases where the courts were slow and it was difficult to get measures. That was the theory, that was the idea. But if you look into practice and if you look at the report issued by the ICC, most of the decisions of emergency arbitrators have been issued in jurisdictions where courts operate normally. There are a few cases in Latin America, there are a few cases in Africa, but most of the cases you will see are in New York and London, and in jurisdictions that you will perceive as jurisdictions where courts are operating in a normal fashion.
Well, I hope I have an occasion this afternoon to disagree with Eduardo, but this isn't one of them. I do have to tell you, though, just today, I issued a procedural order because a party hearing before me had gone to a court for attachment of assets. This is not an emergency arbitrator. And the other party came to us and said, enjoin them. Now, this raised the very issue. We were asked to enjoin a party from maintaining an attachment action during our arbitration. So obviously, they thought there was an incompatibility. They thought that we should enjoin the proceeding seeking interim relief from a national court. And we wrote a very short procedural order saying it's not incompatible. It's not incompatible, and we will not enjoin the effort to get interim measures from a court. And it was a half a page, basically. So it is a live issue, actually. And I think it took counsel by surprise because they just assumed that you can't do that if you're in arbitration. So there you go. We would not enjoin an action in court for interim relief. I don't think you would be reluctant to as well.
Yeah, definitely, yes.
I mean, not when the rules say there's no incompatibility. That if you don't like the order, your recourse is to that court.
Right, of course, yeah.
And at the appellate court.
So the second question would be that compared to its apparent success in the commercial space, the use of emergency arbitrator procedure does not seem to be frequently deployed in investment treaty arbitration. What is the reason, if any, for this phenomenon? In your view, is emergency arbitrator procedure equally applicable in commercial and investment treaty cases?
Would you like me to start this time? Either way. Well, my view is that there is no formal impediment. I think there's nothing definitional. Let me put it this way. I think there's nothing definitional about investor-state arbitration that would preclude the introduction of the emergency arbitrator. We are not seeing it, however. ICSID doesn't provide for it, and even in the current rules, it's not being promoted. UNCITRAL rules don't provide it, and I think, 90% of our cases are either ICSID or UNCITRAL. So it's not that much of a live issue. But Stockholm Chamber of Commerce makes it available, so it's not definitionally off base. What I have thought about, Eduardo, is are there differences, however, between ISDS and commercial that would make emergency arbitration relief, more delicate or questionable in ISDS? And I thought of a couple of things, and I hope we do have a conversation about this. First of all, in principle, at least, an emergency arbitrator shouldn't embark on his or her task without finding that he or she has jurisdiction. Now, it usually isn't an issue. I've been an emergency arbitrator several times, and I've never even thought about having to establish my jurisdiction. But, in ISDS, jurisdictional issues are a little different. And if we, I don't know that we do, but if we required that jurisdiction be established, arbitral jurisdiction be established before the emergency arbitrator can operate, then, wow, we will not resolve the question of whether the claimant is an investor anytime soon. Secondly, I do have the sense that there might be some greater degree of reluctance to award interim relief against foreign sovereigns. This is just an intuition I have. It's been done. In Chevron Ecuador, we had a major piece of interim measure. It wasn't emergency, but an interim measure. But I am reminded, this is a little detour, but in the American Foreign Sovereign Immunities Act, you can attach a foreign government's assets after a judgment is rendered to satisfy it, but you can't pre-judgment under the American statute. You can't.
You have to mute everyone. Otherwise-
So far, it's okay. So, all I was saying was, I think it's revealing that under the Foreign Sovereign Immunities Act, if a state does not have to consent to having its assets attached after judgment is rendered against it, but you cannot pre-judgment attach assets of a foreign government without its consent. So I have the feeling that maybe this idea of, in a sense, condemning a state before it's been condemned, which is an overstatement, you know what I mean. But I think there may be some sensitivities there. And the last thing, and this opens up another question you're probably going to ask, is in ISDS, we frequently have preconditions to arbitration. And it's a question, and I don't think it's been clearly resolved, of whether those preconditions have to be satisfied before the emergency arbitrator can operate, because the emergency arbitrator is part of the arbitration. He may be pre-constitution of the tribunal, and so there is one school of thought that you can't go to the emergency arbitrator if you were required to exhaust remedies, or if you were required to mediate or conciliate. And preconditions are so rampant in ISDS. So, in sum, there's no reason we can't have it. I don't think we will find it that often, and I think there's maybe some degree of hesitancy for the reasons I've given. But it's available in some institutions.
Yeah, there are 2 points in which we agree. We also agree on the second question. There have been a number of hurdles that have been posed in connection with emergency arbitration in investment cases. There are precedents, particularly in the case of the Stockholm Chamber of Commerce. But the cases of the Stockholm Chamber of Commerce have a particularity. Number one, when the treaties were entered into, in the cases of the Moldavian treaties particularly, when the treaties were entered into, the Stockholm Chamber of Commerce rules did not provide for emergency arbitration. They further provided for emergency arbitration later on. So the question is, did the state consent to emergency arbitrator? And responses go back and forth, because some would say, well, they consented to the rules. By consenting to the rules, they consented to any amendment of the rules. But then the other argument says, well, okay, they consented to any amendment of the rules or to some amendments of the rule which are not material. And this is a material amendment of the rules that would require the consent of the state. And number two, if the treaties do not provide for this sort of arbitration, can a rule amend the treaty and force the state to go into emergency arbitrator as a result of amendment of the rules? That's a very difficult question. And it's a question of consent. Has the state given consent to emergency arbitration? So that's one thing. The second thing, our George clearly points out, is whether you can use emergency arbitration to against or to prevent some sovereign acts of the state. And that is a very difficult question. Going to the example of the cases where, the Ecuadorian case, for example, where there was a measure ordering the suspension of a criminal proceeding. Why, if an emergency arbitrator orders the suspension of a criminal proceeding and then the tribunal considers that it does not have jurisdiction, then what? Would probably the person who was in prison is out? The state would have to, start a proceeding from the outset? It's not an easy question. And some institutions, particularly the Icc, has adopted as policy that emergency arbitrator does not operate in investment cases.
Yeah.
And that's a specific ruling from the Icc.
It's de facto. I'm not sure, is it?
It is implicit. It was initially de facto. It is now on the rules. It basically says that when the consent is given in a treaty, then the emergency arbitrator does not operate. And the policy consideration there was precisely that. Can we, by means of amending the rules, change the consent of arbitration given in a treaty that does not provide for this type of emergency measures? So there's been reluctancy, and the only cases, at least of I know, in which these type of measures have been adopted is in the case of the Stockholm Chamber of Commerce, with this particular caveat that they were adopted after the fact. Now, one possible solution, of course, is for states to opt out of the Stockholm Chamber of Commerce provision on investment treaty emergency arbitrator. They could do that. They do not require the amendment of the treaty for that. It would just a change of letters saying we opt out of the emergency arbitrator. That would take care of the issue as far as the Stockholm Chamber of Commerce is concerned. With respect to the other rules, the general rule is that it is an opt-in provision or no emergency arbitration at all, which is the case of the Icc. So that's the actual scenario on that. But I agree with George that there is a lot of reluctancy to adopt emergency arbitration measures in investment cases because the particular nature of that cases and the fact that we're not discussing basically commercial issues but sovereign decisions, which is a totally different animal.
Agreed.
So I would also like to say that the audience can ask questions. But I'll move to our third question here regarding the nature of decisions issued by emergency arbitrators. We know that this nature remains unclear, and there is, in the sense, debate on whether they should be called award or order, although the U.S. courts have rejected such a formalistic distinction. We've been seeing Professor Bermann class in Publicis Communication, True North Communications. But yeah, despite the particular approach adopted by the U.S., this issue seems to be important, at least for enforceability and annullability purposes. So the question then is, should we refer to emergency arbitrators' decisions as orders or awards? Or at the end of the day, this distinction really does not matter. We do believe that a decision ruling on the merits, for example, of the urgent measure, therefore a final decision, should adopt the form of an award, for example. Now, Professor Zuleta, if you could start with this one.
I would say that you will have here different scenarios, that there's not a uniform response to that. You have laws that expressly consider this type of decisions by emergency arbitrators as awards, or at least as decisions that are enforceable as awards, which is the case of New Zealand, for example, or Singapore, Hong Kong. So that's one scenario that to me is clear because the law and you have there the provision of Article 7 of the New York Convention. When the law is more favorable than the convention, then the law would apply. So there's no debate on that scenario. Scenario number 2 would be the countries that have adopted the UNCITRAL model law, particularly the model of 2006. Articles 17H and 17Y, if I'm 17H, H and I, if I'm not mistaken, provide for the recognition and enforcement of interim measures. And I don't see why that would not apply to interim measures issued by an arbitrator, by an emergency arbitrator. The problem, of course, arises, number one, when you don't have the UNCITRAL model law with the 2006 amendment, which there are a number of jurisdictions, you have to be careful on what is a country that has adopted the UNCITRAL model law. 99% of the countries claim that they are UNCITRAL model law countries until you look at the law and you see that they are not UNCITRAL model law countries. They have some aspects of the UNCITRAL model law, but other aspects that are not. And some are not even UNCITRAL model law countries. And not even the UNCITRAL website is accurate on that. If you look at the list of countries that, according to the UNCITRAL website, have adopted the UNCITRAL model law, you will get a number of surprises of countries that are really UNCITRAL model law countries other than not. So that's the first issue of the countries that do not have or have not adopted the UNCITRAL model law of 2006. And then, of course, you have the enforcement under the New York Convention. And there you have an issue, because under the New York Convention, most of the courts, what they have said is that the decision must be final. Final in the sense that it has to decide on the core issue being litigated between the parties, be it jurisdiction, be it merits. And then the question there is whether a decision on an interim measure, which is a provisional measure by definition, because it can be revoked at the tribunal, it is automatically revoked at the end of the proceedings in most of the rules, then is that really an award? I know, and of course, Professor Bermann knows much more about that than I do, but I know there are decisions from the U.S. courts considering that that's an award. I'm not very much convinced of the rationale of the decisions, but there are decisions considering that that's an award. And there are a number of other jurisdictions, mine, for example, in which the court would likely consider that that is not a final decision. And it's not a final decision because it does not put an end to a dispute between the parties, whatever the dispute. You could put the theory that it puts end to the dispute on the decision on the interim measure. But to me, that may be going too far, because the interim measure, by definition, is a provisional measure. The award is not provisional, the decision on jurisdiction is not provisional. So you have four scenarios, really. The laws that provide expressly for the recognition of the decision as an award, the laws that allow the enforcement as an interim measure, because following the UNCITRAL model of 2006, and the laws that say nothing. And then you have to apply the New York Convention and decide under the New York Convention whether that's an award. And I see that most courts would adopt probably the position that, to the extent that it does not put an end to a dispute as such, then it cannot be enforced as an award.
Yeah. Well, I'm not going to disagree with you, but you're correct when you say that in the United States, the prevailing view is that not only interim measures, but emergency arbitrator measures are to be treated as if they were awards. I'm using my words carefully, as if they were awards. And if you read these decisions, unsurprisingly, they all rationalize it in pragmatic terms. Okay. They all say, these are important. We wouldn't provide for interim measures, much less emergency arbitrator measures, unless they were in principle needed, and we need to make them effective. And the prospect of them being enforced is the mere prospect of them being enforced, if they're not complied with, makes them more effective. Now, I will have to say, non-compliance with emergency arbitrator rulings is rare. I think you would agree. So maybe we are overestimating the importance, of encouraging compliance by making these things enforceable when compliance is going to happen anyway. But it is a pragmatic move, and it's simple as that. We want them to be effective. And usually if we want rulings of courts to be effective, if we want anything to be effective, we want courts to be able to support them. And the rationale you gave, the criticism you gave, Eduardo, is one that we faced in the restatement, because we say they are treated as awards. Of course, that's the prevailing view in the US, so we weren't being very radical. But when we had to justify it, we justified it on the basis of what you found unconvincing, that they finally dispose of the question of whether an interim measure is available. But that's, I confess, and I've confessed to my students when we discuss it, that it's a little bit of a stretch to say it's final. But that is the rationale we had to give, that it finally disposes of an issue. And that issue is, can an interim measure be imposed? Even though it's not dispositive of the issue over time. But again, all I can do is defend it in pragmatic terms.
Okay. But would you say that that's one question that I have, because one of the trends that you see is that in arbitration in general and in this matter in particular, of course, there are certain jurisdictions that go well ahead of others. So you have jurisdictions that already accept that that's an award. You have this pragmatic approach from the US and probably in the restatement, but then you have a lot of countries that are well.
Oh, yeah.
Now, what can be done, and that's the key thing here, what can be done to have some uniformity on that? Because one thing, of course, would be to try to include in the universal trial model law or somewhere an amendment to the effect that these are awards if, and this is a big if, the institution of emergency arbitration is as useful and as we all think it is. In practice, what you see is that in the case of the ICC, for example, out of 90 requests for emergency arbitration, in 30% of the cases, the measures were granted. And in 90% of those cases, they were voluntarily complied with. So maybe we're discussing something that is not going to happen.
I admitted to you that this requirement that they be enforced in order to get compliance, the requirement that they be enforceable in order to get compliance is not terribly convincing, because we're getting compliance. But I think American courts simply want to be pragmatic. They want to sound pragmatic, and they don't want, the American courts have this obsession with not allowing form over substance. I mean, it is an obsession in American courts, I think. And I think that plays in here. Like, if it's important, if enforcement could be important, then let's not let the label matter. One thing I want to mention at the outset before we go further, I think on many of the questions you're raising, my answer will not be distinctive of emergency relief as compared to interim relief generally. So I know you're focusing on emergency arbitrators and emergency relief, but in fact, there are many, many ways in which they're treated identically. And I would say, so much so, that if the question comes up about emergency arbitrators, I would operate on a presumption, rebuttable presumption, that they are to be treated the same way as interim measures generally. There may be some respects in which we think, under the circumstances, we should treat them differently. But I was thinking about so many ways in which they're treated the same. And we even answered this question. We answered this question without focusing on emergency arbitration, but rather on interim measures. And I'm struck by the extent to which we assimilate them. And we did in the restatement. We draw almost zero distinction with respect to the court's role vis-a-vis emergency measures and tribunal-ordered measures. I don't know if that's your impression as well.
Yeah, yeah. Would that approach of treating that as an award, or treating that the way is being proposed, would apply both for enforcement of interim measures issued abroad and enforcement of interim measures issued in the U.S.?
Yes, because if we're going to say it's an award,
It's an award for all purposes.
it's going to be an award.
Because that's going to change to the good, I would say, that's the selection of venue.
Yeah,
In the cases of the jurisdictions that have adopted that approach, and in the case of the U.S.
depending what you think you
Game
need.
changer in terms of the venue.
It all depends upon what you know about your case ex ante.
Yeah, right,
So often at play. Do you know where your interests lie
right.
at the time you make your choices? This, I don't know if you're going to get to this, but let me raise it now. Vacatur of emergency awards. Annulment of emergency awards. I mean, we don't really know. We are very determined to enforce them. I don't see the same excitement and enthusiasm about entertaining challenges to them. Although, Eduardo, if emergency measures are so important to the party seeking them, they're probably that important negatively to the party against whom they're issued. We do have, I don't have it in front of me, but in the Yahoo Microsoft case, which some of you have read. Okay, in the Yahoo Microsoft case, it was only an enforcement action, but the court deliberately said, we treat vacatur no differently. So these awards are vacatable. The UNCITRAL model law doesn't take that step.
Right.
And I don't know what you infer from that. I'm inclined to infer that they're not subject to vacatur because they were made subject to enforcement, but silent on annulment. Would you draw that same?
Yeah,
inference?
that could be the conclusion. In addition, because that option, one could think that an option to vacate that would put again the game in the courts, and then the question would be, then why wouldn't I go to the courts in the first place, as opposed to going to the emergency arbitrator and then have to go to litigate in court the possible vacatur of the decision?
To try to distinguish between enforcement and annulment in this context, and why are we so comfortable? Ordinarily, we're not.
Yeah.
Ordinarily, we view them as mirror images of each other. That came up in class today. Okay, enforcement and confirmation and vacatur. But when it comes to emergency arbitrators, or even interim measures generally, I don't see the same feeling that annulment must be available.
Right, right. That's correct, yeah.
I think there is a question here from Mateo.
Hello, my name is Mateo. I'm from Uruguay. I have a question on what are your thoughts on the enactment of national laws that regulate specifics of the emergency arbitrator procedure? For instance, the enforceability of the orders, such as the Hong Kong Ordinance of 2013. Is this a desirable approach or not for you, in your opinion?
It is what, sorry?
A desirable approach.
I think it's a practical approach to solve a problem.
Yeah, what's undesirable about it? I mean, it would certainly give us a little predictability.
Yeah.
I actually would like to know whether my emergency award is going to be enforceable or not. And countries won't agree. We won't get uniform legislation, which you would prefer, I suspect.
It's predictable.
But why shouldn't we have an answer? I don't detect anywhere any opposition to a step like that being taken as a matter of principle.
It's a practical approach. It gives certainty and predictability to the parties, whether one agree or not with the approach, but is an approach that gives predictability to the parties, so you know beforehand that whatever measure you get is an award, and you can enforce it as if it were an award, as opposed to go into this discussion as to is an interim measure, is an award, is not an award, you have the issue with the ICC, for example, that indicates that the provisional measures of the emergency arbitrator should take the form of an order. So there, the practical approach there was it takes the form of an order in order to avoid having to being reviewed by the court, because every award has to be reviewed by the court. But what about the enforcement? Then the enforcement would depend on how the ICC treats the order as an order, or whether the legislation considers the order as an award.
And it's up to the court.
Yeah.
I mean, the ICC can call it an order. I think we know why it preferred that. But a court, at least an American court, is not going to feel disempowered, right, to enforce a ruling merely because it's labeled an order.
Right, right.
But other countries may be more formalistic.
There was some formalistic approach in some jurisdictions in Latin America that adopted initially the position that if it's titled an order or interim award, it was not an award. But today the trend is exactly as Professor Bermann says. The trend is substance over form. So if it's an award, it's an award. If it's an award according to the applicable law, it's an award, regardless of whether or not the ICC court call it an order, an interim decision, or whatever.
You know, an interesting proposal, we didn't do it in the restatement discussions, was whether we should have the tribunal decide, have the tribunal that issues the ruling decide whether it should be enforceable or not. That's, you know, that's interesting. You might think, is it really their job? Do they have authority to determine?
I don't think so.
Does the tribunal have authority to determine whether what they issue is enforceable or not? But it was proposed to us that be part of the analysis, and that tribunals that say it's an award, if they say it's an award, and it's an award. We didn't go there, but interesting suggestion. There's some merit to it, I think, but how much, I don't know.
And I think Andrea has a question, yes.
Yeah, hi. I actually have a question on your thoughts on whether tribunals, emergency arbitrators, can issue orders or what ex parte. You know, is there an issue of fairness?
Well-
Sometimes expediency is key, and then someone doesn't reply and they disappear.
Yeah. Well, in the ICC in particular, and you know this perfectly well, the way it's drafted in such a way, the procedure, I'm sure it was deliberate, it's drafted in such a way that it can't be ex parte. I mean, it's just not consistent with the ICC regime for there to be ex parte. Now, as a matter of policy, I don't know. We certainly, the UNCITRAL model law, and some of you know this, the UNCITRAL model law does provide for ex parte interim measures. I mean, those are called preliminary orders. Some of you may remember. They're called preliminary orders. They're provided by the UNCITRAL model law. And they're subject to very strict rules. They lapse after 20 days. As soon as it's issued, as soon as the order is issued, the other party has to be notified. So ex parte can be mitigated, it can be confined, if you know what I mean. It can be less ex parte or more ex parte. I, however, wouldn't want myself to rule out categorically the possibility of ex parte relief, but I know it's dangerous. But this is one of those, circumstances where you have to say to yourself, might the whole order be frustrated the thing we're developing, this emergency ruling, do we really want to allow it to be frustrated by refusing to allow it to be ordered ex parte? You know what I'm saying? And I hesitate about that. But I would, as I said, I would condition, I think you should look at the preliminary order provision of the UNCITRAL model law, which really hems it in. Lapses in 20 days, there can be no delay in informing the other party. So that's my reaction. I don't know, Eduardo, how you feel about it, but categorically, is this something we want to exclude?
In the case of the ICC, I agree. It is clear that the procedure as it stands has to be, the other party has to be informed. There has been in practice some requests for arbitrations, tribunals or emergency arbitrators to take emergency measures before the emergency measures. In other words, do this before the emergency measures proceedings start. And there's been reluctance on the part of most of the arbitrators to do that. In a couple of cases that I can remember, what the arbitrator did was, okay, I take the measure, but you, respondent, have 24 hours to respond to what I'm saying, for example. So, okay, I suspend, for example, the enforcement of the bond, but you have 24 hours to respond to this that I'm doing. But cases in which the pure ex parte decision has been taken, emergency arbitrators have been very reluctant to do that. There are certain rules, particularly, if I'm not mistaken, the LCIA rules, that could be interpreted in the sense that they allow ex parte measures, because in the wording, and I'm quoting by memory, but you can check that, but the wording, if I'm not mistaken, says that you have to inform the other party to the extent possible. And that to the extent possible could mean that if you can't, then you could take the decision ex parte. But as a general rule, I think that the proceedings for the emergency arbitrator are envisioned in a form such that the other party has to be informed. And that's the reason why, strategically, in a number of cases, counsel decides to go to the courts.
Yeah.
Because if you want to attach an asset, if you want to, you don't want the other party to be informed and then dispose of the asset during the emergency arbitration proceedings. But the general rule of emergency arbitration is that ex parte is a very, very exceptional case.
Yeah, I think that's right. But I think it's not categorically excluded, although it is by definition in the ICC. Right. I don't know if, was that deliberate?
Yeah, that was.
You deliberately organized the procedure so that there would be no ex parte.
It was deliberate in the sense that there was the fear, and it was debated a lot, but there was the fear that a party could oppose the enforcement of the decision, saying, I didn't have the opportunity to present my case, which is a defense that you have under the New York Convention and the most UNCITRAL model law countries. So
that's the reason why you may want to give the target immediate opportunity to contest it.
Right.
So it's in effect. Make no mistake about it. It is in effect. So the requester has gotten what it needed, but it's up for debate within 24 hours.
Yeah.
That mitigates, for me, the due process. I don't know if it's.
Yeah, of course, that going back to the question of emergency arbitration in investment cases, that's another thing that has been contested. If you look at the proceedings in the Moldavian cases, in most of the cases, the state didn't even respond to the request because they don't have the time. The state has a very, the bureaucracy of the state to react and to, if you're given. Let's give a state 3 days to react to an order. It's impossible. It's impossible. So that's another issue that has been risen in connection with emergency arbitration in case of states, because the states would argue that they didn't have the opportunity to present their case because it's impossible for a state to take the measures within.
Well, even to participate, I mean, when you think about the small window of time that emergency relief is organized, I mean, states have to get into gear. You're going to get into gear immediately.
Yeah.
And so, I think that's another factor completely.
Simon.
Can a part,
I-
oh, sorry.
I just have a follow-up question on that. Would that, in the case that you mentioned, where just informing the other party of the fact that the measure is requested might deprive the measure of any effect because you might, sell assets before they are attached? Is that not exactly what ex parte measures are from in court, where you say, I attach the asset, but you have generally a few days or a few hours for the other party to submit the case, and then you will turn that into interim measures? So I have a bit of a trouble understanding why emergency arbitrators should be allowed to take interim measures, but not the next party for a very short amount of time, just like courts usually do, meaning you have saying to the respondent, for example, I grant the order for 24 hours. You have 24 hours to give your reply, and after 24 hours, I can render a decision which will be not ex parte in this case. I see some value to that, and I have a bit of a trouble understanding why emergency arbitrator would be reluctant to do, I think, a mechanism which in a lot of domestic courts has proved to be valuable.
The reason, and I guess I see Professor Bermann said it in the beginning, the reason is that the structure of the rules in emergency arbitration do not allow the emergency arbitrator to take a measure without informing the other party and giving the other party the right to.
It's a matter of drafting. I think
Drafting. Now, what I'm saying is that in practice, some emergency arbitrators, if they're asked to take an emergency measure on the emergency measure, to call it, what they do is, okay, I have to serve the other party anyway. So what I do is give very little time for the other party to react so that I can, on the one hand, say the other party was notified, but on the other, the time is so short that they cannot simply dispose of the assets or do whatever. So it's a matter of the emergency arbitrator, how he or she deals with the case. But it's a matter of drafting. It's a matter of the drafting of the rules. And the rules say what they say. And if an emergency arbitrator takes an ex parte decision, in all likelihood that would cause problems to the decision when it's to be enforced, or at the end, it could affect the award itself.
to take a look at the UNCITRAL model law regime for preliminary orders, because they really did try to make all the limitations that you have suggested. It was deliberated over a long time, because they really thought ex parte had its role, has its place from an efficacy point of view, but you've got to reconcile it with due process, and they did their level best. So that's a good thing to look at as a model.
Right.
Rules could mirror that.
Hi, professors. My question is, can a party go to court for emergency interim relief when their arbitration rules provide for emergency arbitrator and they have not expressly opted out of it?
Yeah, great question. In fact, there are countries whose courts, and India is one of them, in fact, that have said that we will not, if I understand correctly, we will not entertain applications for emergency relief if the rules under which you're operating authorize the tribunal. You must go to them first. And a fortiori, we have cases that say if the tribunal, even if we would entertain it, if the tribunal has said no, no second bite of the apple. We will not override what the tribunal has said. So I think those nuances are there. And that's a limitation on this general notion that you have two parallel tracks and you can do either or both or whatever you want, because there are national courts that are saying, no, you have to exhaust essentially it's an exhaustion of remedies. And it's more than an exhaustion of remedies, because if you attempt that remedy and you lose, then we won't hear you. That's an interesting question. I've told my class, Eduardo, that the relationship between access to a court and access to the tribunal has been left so undefined. There's no priority. There's no notion that there's a primary jurisdiction. It's undefined. So these few states that we've just referred to, they've tried to sort of control it somehow. But in most jurisdictions, each one operates according to its own ground rules without regard to the other.
There are two very interesting provisions. One in Brazil that resulted from a decision of the Supreme Court, basically indicating it is the case. I was trying to check the case here. Is the Itaruma case, if I'm not mistaken. Itaruma Participações versus Participações e Complexos Bioenergéticos, PCBIOS. In that decision, the Supreme Court basically indicated that once if there is a court in measure, once the arbitration tribunal is constituted, then the arbitration tribunal can review and even revoke the decision of the court. But that's an express decision of the Supreme Court that was later on incorporated in a revised version of the law. And there's another interesting provision in a law that I would never expect to find, which is in the law of the Dominican Republic. And in the law of the Dominican Republic, Article 13 provides basically the same thing. It says, number one, that there's no incompatibility between the court decision and the arbitral tribunal decision, and that if the court takes a decision on an interim measure, as soon as the tribunal is constituted, then the court has to send the file to the tribunal, and then the tribunal could either adopt the measure, reject the measure, revoke the measure, do whatever, under the reasoning in this particular legislation that the tribunal, once constituted, has exclusive jurisdiction on matters related to the arbitration, which is a curious provision. Another approach that I've seen is in those jurisdictions where, like mine, for example, and a number of other jurisdictions in Latin America, where the where the arbitrators are considered judges, which I think is a huge mistake inter alia, because if arbitrators are considered judges, one of the things that could happen at the end is that you could end up having international liability of the state for a decision of a tribunal, which is totally nonsense in my view, but it could happen. But in those jurisdictions, then it could be said in certain cases that the tribunal, being a court, specialized court, could revoke certain decisions from the courts. Now, where neither of those provisions exist, then, as you say, there is an issue there, because there is no hierarchy, there is no rank, and tribunals are, on the one hand, reluctant, if in the absence of an express provision or express rule, reluctant to go and revoke a decision of a court. That's a very difficult thing for a tribunal to do. I've seen practical approaches that go twofold. One is to order the party to desist from the measure, which I have my doubts on that, but that's an approach. The other practical approach that I've seen is that the tribunal invites the party, does not order the party, but invites the party to withdraw the measure in the understanding that the tribunal would adopt itself the same measure and keep the measure. In other words, it's sort of a trade. Take the measure out of the court and put it here. In practice, I don't know if parties would buy that, because in the court, they have could have more control of the measure that they have in the arbitral tribunal.
This may sound heretical, but as an arbitrator, I don't think I would I think I would feel authorized to override a judicial measure of interim relief, because interim measures by their nature are circumstantial. I mean, we shouldn't lose sight of it. Bodies revise their interim measures, they can cancel them, they can do, I think it's in the nature of an interim measure that circumstances change. So if there were a judicial interim measure that, as a tribunal member, I thought was no longer apt to changed circumstances, this may sound terrible, but I would feel that I should do that. It's not a ruling, it's not a definitive ruling by the court. It's an interim measure by the court. And I think it's definitional of an interim measure that it's not permanent. And if it's not permanent, then why should I treat it as permanent? I don't know if this sounds heretical to you, but that's how it seems to me. A little tougher is whether an emergency arbitrator should be able to override a measure you got from court on an emergency basis. There I would, you see there's a subtle difference there. I might want the emergency arbitrator to respect the emergency relief that a court granted, especially considering how compressed the time is. But I have some trouble with hamstringing the tribunal by an interim measure that a court happened under a set of circumstances to impose on an interim basis.
Yeah, but in addition, there are situations where the interim measure taken by the court impacts the decision of the tribunal.
Yeah.
Where you ask for the parties are discussing, I don't know, whether a party has a right to suspend a contract, the party suspended or terminated the contract, and then terminated the contract and asking the tribunal to decide to confirm that the termination was made according to the law. And then there's a judicial order that orders the party to continue performing the contract. Yeah. So it's a sort of it's a very difficult decision there. Because on the one hand, yeah, there's a decision from the court, but it's a decision of the court that is having a direct impact on what the tribunal has to decide.
Yeah.
So.
But we always have to think about, for example, if a court enforces an arbitration agreement, but does it on a prima facie ground, then a tribunal should have no hesitation in exercising independent judgment because the court didn't. So I really do think we should look at the nature
of the measure
of what the court did. And if it's truly interim, if it's truly prima facie, I think the tribunal has freedom. But I'm sure there's disagreement in places.
No, I know.
You probably don't have a firm view on that one anyway. Maybe.
No, I see it depends a lot on the measure. I agree with you on that. It depends a lot on the venue. There are venues in which it's almost impossible for a tribunal to give that sort of order, given the structure of the arbitration law. So there are a number of, but I agree with you that there's something that the arbitrators should consider on a case-by-case basis. There is no definitive answers.
I mean, it would be terrible
Not.
if circumstances changed and the interim measure was no longer apt. Do we really want the tribunal to feel bound by it? That's just contrary to the genius of an interim measure. I don't know if I've convinced you.
We have another question. Do emergency arbitrators have power to grant interim relief under the alter ego doctrine, therefore reaching the property of non-signatory? That's a good question.
That is really tough. That is tough. So in case you didn't get the question, If a tribunal, an emergency arbitrator, let us say, is asked to direct an interim measure to a non-signatory to the arbitration agreement on the ground that that non-signatory should be treated legally as if it were a signatory under whatever theory that's being used, to have that authority. Now, a tribunal would, once it made the determination, would. So the question, this is one of those questions where I ask myself, am I going to treat the emergency arbitrator differently? Because we would let a tribunal do that upon inquiry. One reason to hesitate is that alter ego inquiries are very, very fact intensive. I think you're well aware of that, especially the alter ego one. I mean, you've got to look, I told my class about a case in which I argued, in which the Court of Appeals sent the question of alter ego back to the district court and told the district court on remand to consider 26 factors. The Court of Appeals enumerated 26 factors to be taken into account in deciding whether there was an alter ego relationship. Now, you know, for an emergency arbitrator to do that in the 15 days in which he or she has to do so many other things, I don't know if I only think it's impractical or I would simply rule it out, but I haven't decided yet. What do you think, Eduardo?
Yeah, there was that debate took place in the drafting of the Icc rules as well. And the rationale was exactly as you were presenting it. The decision of whether or not to bind a third party to the arbitration agreement is factual. And it may require a lot of additional evidence. It may require even a hearing. So in practice, what the ICC ended up doing is to include in the rules a provision to the effect that the emergency arbitrator can only issue measures to the signatories of the arbitration agreement, which is a practical approach. If you sign the arbitration agreement, because prima facie you're a party to the agreement because you sign it, to avoid a situation where you would go and litigate forever whether or not the third party is, and let's assume that the arbitrator, the emergency arbitrator, in a rush, in 15 days, decides that you are a party to the arbitration agreement, and then issues a measure. And then the tribunal, in finding its jurisdiction, decides that you're not. Then what?
Yeah.
So the practical approach of the courts, of the rules have been, if you're a signatory, then you can ask for emergency measures against another signatory, but that's it.
I think the ICC took the view that let's not do this on a case-by-case basis.
Right.
Very often we do things on a case-by-case basis. But the difficulties and the impracticalities are so great, the time limit is so, let's just
rule it out.
Preclude it.
Yeah.
And sometimes case-by-case is not the best way to go.
No. I was mentioning to Natalia before coming in, there was a debate in Colombia as to the possibility of granting interim measures against third parties, ex parte. Why? Again, because the judges or the arbitrators are considered judges. And fortunately, at the end, they decided not to do that. Number one, because an emergency arbitrator, appointing an emergency arbitrator and granting the authority or her the authority to grant ex parte measures could end up in situations where, for example, the emergency arbitrator has a conflict of interest.
Oh, yeah.
That only surfaces once the measure is taken and the other party is served the process. So that's one thing. And the other thing is that even though arbitrators are, quote unquote, judges, that's a theory that has to be revised. There's a recent decision in arbitral tribunal in one of the other BREC cases in Colombia where the tribunal decided on the rights of third parties who were not a party to the arbitration clause. The banks were not a party to the arbitration clause, and the tribunal ruled on the rights of the banks, which is totally absurd under the theory that they're judges. So I don't think that going back, that the third party should be affected by emergency arbitrator decisions.
I think that's a sound, practical compromise. One thing I want to mention, because it may not come up in your questions, but I think it's important insight. We're assuming emergency arbitration mechanism is available. But let's just for a moment remember that in ad hoc arbitration, it's not there. It's not there. We're assuming an institutional. I think if you think you need emergency relief, you're probably not very well off ad hoc. I mean, are we going to get emergency arbitrators in ad hoc arbitrations?
I don't think so.
I don't
think
see
so.
how that would happen.
No, I don't think so. I don't think so.
I mean, it can't be. The tribunal isn't in place yet. There's no institution. So that's one of the underappreciated differences between ad hoc and institutional arbitration that only arose when we started having emergency arbitrators. I'm sure you would agree.
I agree with that. Entirely.
And maybe that makes the desirability of ad hoc arbitration even less. Even less than it already is. It's commonly viewed as less desirable.
Yeah.
And here's a very clear example of a useful mechanism that would be unavailable to you in ad hoc. At least I think it would be.
So
One of the questions that has been put is whether emergency arbitration was really necessary, whether it would work in the future, whether it's simply a sort of a follow the leader trend that the Icc did that, then everybody has to do that.
That's true.
It's something that is evolving. It's something that is still to be seen. I encourage you to read the report of the Icc task force, because it's a very good report that will put you what in practice happened.
It covers 2012 to 2018.
Right, that's correct.
There were 80, am I correct?
80 cases.
There were 80 applications. And so there's a body of experience upon which that task force was based. And it's well done. It's an easy read.
Yeah. And it gives you a picture of what really this is about. Is the practical application of the emergency arbitration rule as opposed to the theory in the abstract in Jupiter on what
And
what
to
is
the
this?
extent that we take probable success on the merits,
Yeah.
the more we take that into account, the less comfortable, how well situated is an emergency arbitrator to make any assessment of probable success on the merits?
I think there's time for the last question because Professor Bermann has to take the train.
Thank you. I have a lot of questions, but I'll try to ask just one.
There's email.
Yeah. Let me think which one I want to know better. I think I'm struggling following up then what we're just saying about the practical purpose of the emergency arbitrator, because in legislation such as Brazil, an emergency arbitrator order will be like an interim relief, because the arbitration rules in Brazil, the arbitration law, says that before the tribunal is constituted, a party can resource to national court. And then I'm thinking that sometimes we can have parallel proceedings under an Icc arbitration, and then another party that goes to court, and how would that look to parties? Because then maybe another party, the one that seek the emergency arbitrator, will have to seek the court to enforce the emergency arbitrator order in order to, I don't know, the arbitration to prevail. What do you think on that? What should parties do?
I'm not sure I caught it exactly. Maybe Eduardo, you did.
No, I did not.
I'm just
Put
curious.
differently,
Parallel proceedings. How should parties, not now taking the view of the tribunal, but as counsel for parties, how should parties act with parallel proceedings? Because the tribunal then later on can revoke one order or the other, correct? And how should parties do? How should parties deal with parallel proceedings? If one party starts an emergency arbitrator, the other party goes to court, and regarding the same thing maybe, and they have distinct decisions?
I think generally speaking, the problem is they are parallel. And so each one will follow its course. Now, we all know that under some circumstances, a court may issue an anti-arbitration injunction. I can't imagine an emergency arbitrator issuing an anti-suit injunction. I've never thought about that, but it's quite a concept, isn't it? Emergency arbitrator issuing an anti-suit injunction. But, I think you just have to reckon with the realities of parallel litigation.
Yeah, I agree. You have two scenarios really there. One scenario would be the case where the two parties are requesting the same measure. I think it's very unlikely but one party is seeking a measure from the emergency arbitrator and the other party is seeking the totally opposite measure from a court. I see that very difficult to happen. What could happen is that one party decides to go to the emergency arbitrator for a measure, and the other party decides to go to the court for a different measure. And then you would have to live with both.
They will
follow the course of both. There's no way you can force the emergency arbitrator to question the decision of the courts or vice versa. And depending on the applicable law, then the tribunal may or may not revoke one or the other decision, or both, and take both.
Or both.
But you cannot, the parallel proceedings, if each party goes to a different forum, you cannot do anything other than follow the course of the two proceedings.
And I don't think there's any prohibition on what you're contemplating. I don't think it is prohibited. I don't think it's inherently to be forbidden that one party goes to court for interim relief and the other party goes to an emergency arbitrator for interim relief. Isn't that their prerogatives?
Even one same party could go to the court for an ex parte relief and then to the emergency arbitrator for a relief that is not ex parte.
But you're imagining the two parties, is that right?
Yeah.
Your question, is it?
No, but in a scenario that one would go to
Okay.
the other to court.
Okay.
And might have conflict decisions.
Yeah. Well, there's nothing, I don't think a party is forbidden to exhaust both at the same time. It's a free-for-all, as we say.
Yeah.
There's just no ground rules with respect to the relationship.
Right.
Each one has its ground rules. Believe me, in a court, there will be ground rules on how you get into a measure. But there are no ground rules on the relationship between the two, except what we were talking about, where we have a legal system that says, if you can go to the tribunal, you may not come to us.
Right.
But that's the exception.
Right.
That is really the exception.
Thank you all very much.
It's my pleasure to be able to chat with you.
No, it's my pleasure. It was great.
Person, imagine that.
Yeah, we were chatting the last time that we saw each other in person was the Columbia Arbitration Day in March of 2020.
It was the last event, live event at Columbia Law School.